to Covered, the insurance law podcast for corporate policyholders. I'm Vince Morgan. Joe Cox, welcome to Covered. It's great to have you here today. And we normally, our podcast is the insurance law podcast for corporate policyholders because there are lots of podcasts and a few of them about insurance and even a few about insurance law, but really none that we know of from the standpoint of corporate policyholders. And so we love to get online with some folks who have different perspectives that we can share with our clients and friends about these issues from a legal standpoint and otherwise. And so we're delighted in our program in the past. We've had brokers, we've had risk managers, we've had other insurance lawyers, we've had even one in-house at an insurance company, which is, of course, on the other side from us. So we call that Tales from the Other Side. This one we want to call Tales from the Bench because this is the first time we've had a former judge. So, Joe, welcome. And we've actually, I guess, we've had a former general counsel. So again, happy to have Tales from the Bench and to hear a little bit about your experiences as a judge on insurance cases. So, Joe, why don't we start with tell us how long you were on the bench and how you got to there and then what you've done since. Tell us a little bit about that, just so our listeners have some background for who you are and what you've seen.
Sure, Vince. Thank you very much. Happy to be here. Well, I was on the bench back in the early 2000s and served a term, as most people here in Dallas, where I am, who know me know that prior to joining the bench, I was at a firm called Hughes & Luce and then went to the bench. I followed in the footsteps of one of my former colleagues, now a federal judge named David Godbee. And so I followed his footsteps to his bench, served a term. I had 2 kids born while I was on the bench, one right before I took the bench. So with the amount of kids coming, I decided it was best to leave the bench and go back into private practice, and that's what I did. And I spent about 7 years at Patton Boggs, and now I've been 10 years here at Bracewell.
Well, good. We hope that you've enjoyed that. And I know Judge Godbee, very bright judge, of course, his wife is also does a lot of coverage work. So, I'm sure you guys have chatted with them about that. But tell us if you think back to your days wearing a robe for a living, and how much of your docket would you say as a state court trial judge in Texas, you have a very varied docket, right? I mean, you've got everything from sort of car accidents to real estate disputes to will contests to, maybe not those.
And everything.
And then, commercial litigation, everything, right? So right. How often would you say that you had insurance issues before you to decide?
I would say back then it was probably just about 5% or so. There were a lot of cases that turned into Stowers cases and things like that, but it started out as just regular plaintiff's cases, as you know, can turn into then a Stowers sort of case, and those take a new life of their own. But just flat insurance coverage cases, probably 5%. They were usually, in my court, they were usually businesses who were trying to seek coverage, and then the insurance company saying, no, we don't owe you coverage either for wrongful death or torts, dram shop liability, things of those natures, business interruptions and things like that.
Yeah, that sounds pretty standard to us. Now, I wonder, I don't know, I'm not sure if anybody really tracks the statistics on new filings. I guess somebody probably does. My guess is the number of insurance cases today is probably more than 5% of an average trial court docket. I mean, my sense is that the volume of insurance litigation has gone up. Of course, we just got a couple of opinions from the Texas Supreme Court a couple of weeks ago that now the duty to defend is now something that we're going to figure out is extrinsic evidence admissible, and that is almost certainly going to lead to more litigation and judges weighing in on that kind of stuff. It used to be a pretty simple test. Now you've got a test within a test and or a test to figure out what the test is, I guess is the best way to think of it. And so that number is probably going up. That's my sense. Do you have a thought about that?
Yes, I tend to agree with you. I think from what we've seen over the last 2 years, all these insurance cases over coverages for COVID and things of that nature, business interruption, those have seemed to have taken the forefront. I still think the docket has moved, but I would say it's probably still less than 10% for coverage cases for state court judges, and probably the same for federal judges as well if you take into account their criminal dockets. But you can see in the Law 360 and these other services, the amount of insurance cases that are coming out, the decisions that are coming out around the country on COVID issues and things like that for coverage. And so I think it's more in the forefront of people's minds now than ever, but I don't think the volume has gone up dramatically. It may look like it has, but I still wouldn't think that it's a big docket mover on courts cases these days.
Yeah, I suspect that's probably right. Now, I'd love to hear your perspective on this. I mean, we go up against all kinds of insurance company lawyers. Some of them are good friends of ours. We see them, in case after case after case, and we have developed a good working relationship. We, have a high level of, respect and trust for each other and that kind of stuff. And then sometimes we see new participants, and that's fine too. It's always, an opportunity to make a new friend and colleague. Things work out the way they should, and that happens. Doesn't always happen that way, but hopefully does. But my sense, whenever we're in court arguing against some insurance company lawyer, the bombastic ones that just go in there and say, Judge, this is ridiculous. There's no way this is covered, blah, blah. And they're just over the top with their rhetoric. I mean, those lawyers we don't really worry about. The ones that come in that are sort of very mild-mannered and soft-spoken, well, Your Honor, we need to unpack this. And they kind of take their time. Those are the ones that we find to be more difficult opponents. What was when you were a judge listening to lawyers, what techniques, do you have the same sense of that? Or did you take a different approach? I mean, because you must have listened to lawyers all day, every day. What approaches worked well that you thought and which ones didn't? I'd love to hear that.
Sure. I can tell you that being a state district judge and a judge in Texas, you'll see level of counsel from almost incompetence all the way up to what's the finest. In any type of case, it's not typical of insurance cases. I'll say that the volume defense lawyers, car crash lawyers, over time they get better and better because they're in the court so often. I saw lawyers change and get a little bit better each time they tried a case or each time they argued something. But I find that lawyers who know the pleadings, know the documents, know their case are the lawyers that do best in front of any judge. Because oftentimes I would ask lawyers when, for example, if they're requesting documents, I'd say, what's in your pleading that supports you to get that document? And half the lawyers couldn't tell me what was in the pleading of the latest live pleading that they had. And I'd say, well, I've read it and you're not requesting that relief. And so it's not really, it's sometimes how you present it, but it's more, you have to have a knowledge. The good lawyers have a knowledge of their case, of their last live pleading. And when they come to court, they tie that all together with what relief they're asking for. Hey, Judge, we want this relief because as we pled this relief helps us. We want you to find that their defense of X is not valid because of this fact or whatever, and that ties back to our original case. It's however you can, it's the best way to present it, which is knowing your own case is what I found to be the good lawyers. And if they knew their documents, if they knew their last live pleading, those were the best. And also the best lawyers knew when to stop talking.
Yeah, now that last one is a really important skill. At some point, you're not saying things that are new, right? The judge has heard enough. At some point, I mean, what's the old line? If your opponent is shooting themselves in the foot, don't get in their way. Right. Don't interrupt them. And that's always something to think about, too. And I remember, in fact, my second hearing, went down. My first hearing, it was in Dallas County State Court. I've been licensed a day and a half. Sworn in on a Monday afternoon. My first hearing was Wednesday morning, 9 a.m. And my boss didn't show up, which was awesome. There was a live witness on the stand, and I'm thinking, okay, I should start talking. But my second hearing, there was a lawyer that was arguing on some issue, and she was talking about went to state of mind and things like that. And the judge just started arguing with her, and not arguing, asking questions. That's a better way to say it. This judge is asking the questions that I would be saying, so I should just shut up and not get in the way. And just, it seems like the judge is focused in on the problems here, and I'm just going to let the judge do that. And I was lucky to see that really early in my career, how that can work, right? But I don't think if you haven't seen that, then that's a hard lesson to learn. So I was lucky. I guess the stars lined up for me right away. But Anyway, that's interesting. So know your case and then know when to stop talking and pay attention and all that kind of stuff. What other thoughts have you seen in terms of what worked with juries, right? I mean, same kind of thing, or do you have a different sense for what persuades juries in insurance cases?
The jury trial is difficult for a lot of lawyers, from voir dire or voir dire for those folks on the East Coast or somewhere else other than Texas. But that's tough. Making an opening, putting on witnesses, closing, and then making closing arguments. It's a tough burden. And some lawyers are better than others at it. And those lawyers are the ones that relate to the jurors and get them to buy in to what they're saying, that get them willing to make a decision in their client's favor. And by that, I mean they draw them in. And what good lawyers do is they change their volume, they change their tone. If you can get a jury to lean up and hear you whisper something to make a point, you ought to see how the good lawyers draw the jurors into them. Because jurors watch everything during a trial. They watch the judge, they watch the bailiff, they watch the court reporter, witnesses, and they definitely look at the lawyers all day long. And so they'll watch lawyers, and if lawyers are rude to their staff, rude to the other side, rude to the court, rude to anybody in the courtroom, they see that, and that lawyer then gets a mark on them.
Right.
And so you've got to know that. But the good lawyers know their case. They know how to do a voir dire that's not, you're not arguing your case, but you're making the points to the veneer panel that you need to be made in order to strike the jurors that you don't want. And then the same thing goes for opening. You draw the line between opening statement versus a closing argument. And a lot of times lawyers will object to saying that she's arguing or he's arguing in the opening statement, which the court sometimes will sustain. And so there's all sorts of fine lines you have to walk when doing a jury trial that are different from a bench trial. Whereas in a bench trial, I could ask questions of the witnesses if I wanted to, right? But in a jury trial, I'm not going to do that. And so the lawyers then are going to have to figure out what is it that the jury wants to hear. Now, I would allow jurors to take notes. And then I would ask the lawyers, do you want questions from the jury after each witness or at the end of each day that you can address then the next day or put the witness back on the stand? Some would agree to it, some wouldn't. But the ones who did agree to it would get a great insight into how their case is going. It's fascinating.
Yeah, who wouldn't want to know what the jurors are wondering about?
Yeah, wouldn't you?
Why would you say no to that?
Well, because some lawyers don't understand the benefit of it.
Gosh.
Good lawyers know, let me hear what the jury's saying. Especially a good plaintiff lawyer is going to say, yes, if you think I missed something, write it down. We'd collect the notes. I'd look through them. I would look through the questions if we got any, share them all with the lawyers and say, do y'all want to agree to answer any of these?
Wow.
Either side, y'all let me know.
That's incredible.
But here's what the jury's thinking. Do you want to put on your witness back on, or do you want to address this the next day? You'd be surprised. I mean, the ones where the lawyers would agree to that and agree to that system, both sides felt that the jury came to the right decision.
Sure.
Regardless one side lost or not, obviously one side's going to lose, but both sides would feel that they got a fair shot with the jury.
Right.
And that the jurors thought some evidence was better than other evidence and things like that. But there's a big difference between lawyers that can try cases to a jury and lawyers that can't. There's a big divide. It's not like everybody's pretty good at it. There's a group that are exceptional at it. There's a group that's pretty good at it. And then there's a big group that's not very good at it.
Sure.
And so it's tough. Trying a case to a jury is tough. Don't underestimate it, and I know you don't, but your listeners shouldn't underestimate it. It is tough work for a jury trial. It's for the lawyers. Very tough.
Right. No, that's for sure. And but I'm still just a bit stunned that there are lawyers who wouldn't want to know what a juror is thinking. I mean, I just don't understand that. Because, I don't know. I mean, they're the ones who are going to decide what happens in your case. So you might want to know what they think, because they're going to tell you later on if you don't hear it now. Right. I mean, they're going to be answering their own questions. Yeah.
I've always felt it was very beneficial to defendants in the cases who are trying to defend a position to say, boy, is the plaintiff, are these witnesses the plaintiff putting up, are they really hurting us? I mean, are they? And then you can get some notes from the jurors who says, I didn't understand the testimony of Jim Smith. I didn't understand the testimony of Jill Scott. Help me out. Did she say this? Did he say that? And you can answer those questions. If you thought it was easily and clearly shown and the juror saying, I didn't hear that answer, or what was that? You would want to know that, wouldn't you?
You would want to know that. You would want to know that.
So
you'd want to go back over and address that again.
I tell lawyers nowadays, listen, if you're going to go try a jury, ask the court if you can let them take notes and get questions from them.
Yeah.
And
that's really good feedback.
Or at least at a minimum, take notes, because you want jurors to sit there for 3 or 4 or 5 days and try to remember everything.
Yeah, it's a hard job.
Yeah, it's a tough ask, especially when they've got, some of them might carry their phones into the jury box with them, although you don't want them to. They got other stuff on their mind. They got kids, they got jobs, families, and there's a lot of stuff out there, and let them take some notes.
Right.
I think even federal judges will, if the lawyers agree to it, will let them take notes. You just have to ask. Some are sticklers more than others, but most of them will say, sure, they can take notes as long as they just can't take them with them at the end of each day. You just leave them there.
Yeah. No, I'm on your train wholeheartedly. Now, something else that, we run into with, I think there's in litigation, this is so many other aspects of life these days. There are some folks who feel very confident in their views, right? And rightly or wrongly, they just, they have firmly held convictions, and they think this is, kind of the way that X, is or should be or whatever. And then, of course, that's fine. And sometimes, and I see this, I get the sense that it's happening in the other side's camp, right? I mean, I don't see into their camp, but I get the feeling. And then sometimes I know it's happening in our camp. And there's always this idea of, can't you just go down and explain this to the judge and get this figured out? Well, our system is designed for that not to work, right? It is designed to make sure that every case gets the appropriate amount of due process, right? And we bend over backwards and, to make that happen. And the consequence of that, which is a negative, is that litigation takes too long, costs too much, and it's inefficient, right? But it is that way because we value due process, right, far higher than we value efficiency, right? And we want to prevent cronyism and corruption and all of those things, right, that you see in other legal systems and whatever. And so I just say, this is just the system that we have, and again, it has its faults, but it's designed that way on purpose to avoid bigger problems, right? So is there anything that you saw that worked, that preserved sort of the good parts of our system, but also managed to kind of manage better the unfortunate consequences of it? I mean, is there anything that you saw was an efficient way for lawyers to work through their cases? I mean, we try and agree where we can on everything from discovery to deadlines, whatever. I mean, we try very hard to work with our opposing counsel and work cooperatively. But so obviously that helps if you're fighting all the time, and that makes this problem worse. But did you see any particular techniques that with respect to coverage cases? I mean, is it early summary judgment motions? Is it anything that helped resolve this stuff sooner? I mean, if parties would just put X issue in front of you as a judge, it would make the rest of the case kind of go from there, or whatever. Any thoughts about that? Sure.
I think that lawyers should use the courts to get answers that will help them become more efficient and also help move cases along. And one old judge told me one time, he said, listen, you can file a motion for anything. It doesn't have to be in the rules. It doesn't have to be called anything. But just bring it down to the court if you think the court can help you. And I'm not saying just file something just to file something, but sometimes you can use a motion. Let's say it's a motion to compel, or a motion to maybe in an insurance case, you want to have them put the policy limits into the registry of the court, for example. Maybe you want to ask for that sort of extraordinary relief, right? You think the insurance company is going to get downgraded in their investment, and it goes to some sort of junk status or whatever, some crazy scenario where you think the insurance company may go out of business, and you say, hey, let's get down there Let's file a motion to have them place the money into the registry of the court. No harm to them. They'll get it if they win, but we'll have a surety that it's there because we think they're going down, and then you come in and you argue that. You can use something like that to educate the court as to what's going on with respect to the underlying litigation and where it is. Judge, listen, they won't give us this, they won't give us that. It makes us worried that they're going under. They won't tell us what their reserves are. They won't tell us this, they won't tell us that. You may not win that motion to make them pay it into the registry of the court because it has a different standard. You have to show certain things, but you can use that motion to educate the court as to what's going on and maybe get the judge to look at the other side and say, hey, insurance company over there, why are you not covering this? It looks pretty straightforward from what I just heard. Tell me. And so I would see lawyers use motions every time you're down there. I take this mantra. Every time I go to court, I want to tell the judge something about what's going on in the case so that the judge knows why we're having this argument or why this case is still going forward. And if that issue is, I want to tell the judge, look, the other side's being unreasonable with their document production or their presentation of witnesses or whatever it is, give the court the information to understand what's going on in the background outside of the case that the judge never sees. And that's how you can use the system and work within the system to bring to the court issues for relief that you may not win, but it'll be a chance for the court to get an idea of what's going on. You're not going to win every hearing. You're not going to lose every hearing, right? At least you hope you don't. But you want to get down before the court with your ideas and your understandings and see if the court can, as you just said, turn to your opponent and say, hey, what's going on here? What am I missing? Why are you arguing so hard about this? Why are you not just covering it? Why are you not telling them A, B, C, or D? That's what you really want, right? At some point. And then once that starts happening, if somebody's chiseled in and has entrenched themselves in their view, and when the court starts talking to them about their view and how it may not end up that way, that's when they start to loosen up, is what I've seen and what I found.
Yeah. That's helpful. Sound advice. All right. So, Joe, we're running up on the end of our time here, but we have a tradition on this podcast of asking our guests what is the craziest insurance claim they ever saw. Do you have a memory from a case that you handled as a judge or as a private litigant? Anything that jumps out at you of this is the craziest insurance claim I ever had to deal with?
I do have one that sticks out to mind over all these years. I had a case in my court involving an outbreak of some sort of disease that hit a chicken farm. Most people don't know this, but hundreds of thousands of chickens or probably 1 million around the country are killed every day. They're mostly electrocuted, in case you didn't know that. But neither here nor there. That's a chicken story for you. But they were arguing over the chickens got some sort of disease and a lot of them died off at this one facility. They filed on their insurance, said, we want you to cover it. We want to get our business interruption insurance for this. Insurance company said no. They filed suit and they were seeking $25 million, which was a policy limit. And so they were arguing over that. We had several hearings. It went on. And eventually the case settled. We didn't get to the trial of it. It eventually settled after various rulings that I made in order to let the insurance company know, I think this is going to be a covered event based upon what the policy says and what's been pled here. Very interesting. Lots of money. People don't realize how much money is involved with business interruption and insurance cases. They get good lawyers on both sides, big names, not people that are going to make the court mad, but people who know how to address a court and how to argue and try cases. And they're good lawyers. It was just an interesting, fascinating case because I learned about chickens and how they got diseases, but as well as that, does this insurance, does it cover you? Does it cover the claim?
Wow. Well, that is very interesting. Sounds like you got to the right result, which is, it's covered. In fact, that's what we named our podcast, right?
Right.
Well, good. Well, that's great. That's a great story. We've heard an animal story before. There was I think it was a rhinoceros that got cancer. And the allegation was that some materials that were donated had some carcinogens in them. And apparently they got out of that claim because they disposed of the carcass and it couldn't be tested. In any event, now we have a chicken farm, so that's good. We continued to expand. Last episode, there was a case with a serial killer, which was a lot less fun. But nevertheless, this is why we ask, right?
Right.
And insurance has some really crazy stuff sometimes. I mean, in the sort of pantheon of good lawyer stories, right? The divorce lawyers they take the cake. The employment lawyers are sort of number 2. The criminal lawyers are number 3. And I think coverage lawyers are probably we come in 4th in terms of interesting stories, but that's a good one. So thank you for that.
And I always think, just before we go, I just want to say, I always think there has to be a listeria insurance case for Bluebell somewhere out there filed and already done by now.
Yeah, that's probably right. Right. All right. Well, listen, Joe Cox, this was really great. We really appreciate your insights as a former judge and sharing them with us. And of course, you're one of my partners, and always nice to talk with you as her. This has been super helpful for our listeners who most of their claims get worked out, as they should. But every now and then they find themselves in disputes. And this is, I think, the kind of insights that they always want to look at and kind of understand a little bit more about the process that sometimes seems hard to understand. So appreciate you sharing your insights. I'm sure our listeners will really enjoy it. And I hope that one day soon you'll come back and share more stories from the bench with us.
Very good. Thanks for having me. Really appreciate it.
All right, Joe. Thanks. Have a good day, sir.
You too.